All right, so we're so C is the correct answer for number one. But let's look at A. Grant the motion as to the marijuana, but not as to the money or the gun, because the money and the gun were found as a result of the protective sweep for the defendant's accomplice. So that's not okay because they were still in the house improperly. So anything found with respect to that would be fruit of the poisonous tree, and it's barred under the exclusionary rule. So A is out. B, grant the motion as to the money and the gun, but not as to the marijuana, because the bags containing the marijuana were clearly visible on the dresser during the search. It's wrong for the same reasons. They were still in the house improperly, so had they not been in the house, they wouldn't have been able to see on the, oh. Oh. Can the rest of you hear me? Okay. Oh. Could you guys hear me before when I talked through the whole question? Okay, cool. All right, thank you. So I don't know what was going on there for a second for you. Um, oh. Um, it might be because I live out far and we're having bad weather, so like I just got a little message. It like messes with my Wi-Fi sometimes again because I have um solar panels and that's where we get our electricity, so sometimes like that gets messed with. So that could have been that's probably what happened there, but let me know if you guys have any other issues. All right. So B is incorrect for the same reasons because it's they were improperly in the house, so anything that they obtained anything obtained is fruit of the poisonous tree and is barred by the exclusionary rule. So C is our correct answer, but D, deny the motion. Deny the motion as to all of the evidence C's. That's just the wrong result. They shouldn't let in any of the evidence. So C is our correct answer. The crime wasn't ongoing. He had reached a place of safety. So Adam, you thought the crime was maybe still in progress. And it's not. So once he'd gotten to his home, he's reached a place of temporary safety, and they're no longer in hot pursuit. So that's why. And then Sarah, a few hours after the robbery. So exigent circumstances, generally speaking, exigent circumstances is going to be something that's going to show that that somebody is going to immediately destruct evidence if they know that that they're going to be arrested or that they're going to flee. But because it's a few hours after the robbery, he's home and they haven't like he doesn't seem to be aware that they're onto him or that the money's been tracked. That's why there's not an exigent circumstance. So like I follow the news pretty closely, and places city crime is over. So an exigent circumstance. So like it's not precisely on point. Let me see. Like it would be an exigent circumstance if they knew that he was coming. Um, if they knew that he was coming, or he knew that the police were coming and that he was going to destroy evidence as soon as he saw them, or like he had something in his hand and he could swallow it and that would destroy the evidence, or something like that. That could be an exigent circumstance. I also know, like in the news the other day, like things can be sealed. Oh, that's too different. That's too different. So I don't want to do that. So you should have some way to know that he will destroy evidence, or there's going to be like some sort of like somebody might die if they don't go in. So something like that. It's going to be destruction of evidence or like serious bodily injury. And then Andrew said, in order to have been able to enter, they would have had to have taken the bank's GPS. Yeah, they would have had to get a warrant because he was inside his home, and there was nothing to show that there was any exception that applied. So they would have had to get a warrant. Yeah, and there is the rule, like if you knock and announce your presence, then you might be able to enter. But that's a classic. Like I think of the show Cops when I used to watch that. But that like those are scenarios where there might be like I think like where someone is generally fleeing, whereas like here they're not. He's not. So, all right, let's look at the next one, question 2. So may the defendant be charged with attempting an illegal purchase of drugs. So remember, with an attempt, you have to have the specific intent to carry out the crime, and you must be committing a crime, or it must be the thing that you're attempting to do must actually be illegal. So, all right. So an attempt, and you have to make, I think it's an overt act. Yeah, it's an overt act. All right, so going through the fact pattern, believing that the state law made it illegal. So as soon as I see the word believing, I make note of that because you always want to pay attention to what, um, what somebody believes. You always want to pay attention to state of mind words. So here it says believing that state law made it illegal. So as soon as I see that, I'm like, okay, so it's probably not illegal. Um, so, so then I'm like, okay, well, yeah, attempt is substantial step, dangerous proximity. Yeah. Um, so as soon as I see that, I think that it's not actually going to be illegal. So I think legal impossibility. Um, So, believing state law made it illegal to purchase a certain drug without providing identification and signing a logbook, a defendant purchased the drug without doing so. So this tells you that he knew that there was this law and that he was attempting to violate it. So that like those facts there show the specific intent to carry it out. So like I want you guys to keep that in mind because going forward, if you're looking at an attempt question, you have to see that they wanted to carry out the offense. So that right there, if this was illegal, then that would have been an attempt. So unbeknownst to the defendant, the state legislature had repealed the statute and the drug could be legally purchased without providing identification or a signature. So you're doing something that's not a crime. So you can't be charged with an attempt to commit a crime when the act that you're doing is not illegal. Yeah, so that's why. So it's a legal impossibility. It's not a factual impossibility. So you got to, and this question is really testing the distinction between those two things if we look at the answers. So make sure you have those straight in your head. A legal impossibility is you think that it's illegal to do something, or you think it's illegal to do something, but it's not. That's legal impossibility. Factual impossibility is where you're attempting to do something that's illegal, but because some fact is not present, you weren't unable to carry it out. So there's an essay that tests this where there is an essay that tests this where there is a guy who is lighting it is a crime to light a copy of the US Constitution on fire, but he thinks what he has is a copy of the US Constitution, but it's actually a copy of the Declaration of Independence. That is a factual mistake. So that is not a defense to attempt. So an attempt is something, but for something happening, the crime would have been committed. So, it's like you pull the trigger on the gun, but the gun malfunctions. That's an attempt. So this is the same thing. So, or that scenario I just gave you with the burning is the same thing. But here it's a legal impossibility because it's not a crime to do something. So may the defendant be charged with attempting an illegal purchase of drugs? And the answer is no. So it's just which reason. So because the repeal of the statute made it factually impossible for the defendant to be guilty of the charge, that's incorrect. It's not factually impossible, it's legally impossible. It's true that factually he cannot be liable, but it's impossible for him to be guilty of something that's not a crime. So then B. So A is incorrect. B. No, because the repeal of the statute made it legally impossible for the defendant to be guilty of the charge. That's correct. The repeal of the statute does make it legally impossible because it's literally not a crime to do it. And then C and D are the incorrect results. So they both say yes. Yes, because factual impossibility is not a defense. It's not factual impossibility. It's legal, but it's still the incorrect result. And D, yes, because legal impossibility is not a defense to attempt, and it is. It is. So any questions about that one? Okay. All right. Question 3. So again, we'll read the call of the question. If the defendant moves to prevent introduction of the confession into evidence. So the two words in here that tell me, or 3, that tell me that we're in Crim Pro is prevent introduction. So that's another way to say suppress. And it's of the confession. So there's a confession. So I think that it's going to be a confession that might be the defendant's essentially asserting that it was illegally obtained. So his rights were violated. So if the defendant moves to prevent introduction of the confession into evidence, should his motion be granted? All right, so let's look at the facts. The defendant broke into a woman's house one night. As he was collecting valuables, he was surprised by the woman. So he's committing. So if you don't read the call, you're going to think you're in a burglary question here, and you've got to be careful about that. That's why it is really helpful to read the call of the question first. I often will tell people, and you may have heard me, I will often tell people, like, don't look at the call and don't look at the answers, like, figure out what's going on. Or actually, I really just say don't look at any of the answer options. Look at the call and then read the fact pattern and figure out what is the issue here. And I want you all to be able to do that. And that's why when I go through these problems, before I look at the answer options, I'm identifying what is the issue. And that's why it doesn't, the goal is to get it down to one, to know the answer and then look for that answer on the page. Not to think kind of maybe what's going on, or there's a few different issues, and then you see, because if you see that there's multiple different issues and you don't know what they're testing, then you're going to get it down to two and you might get it incorrect. And the goal is to avoid that. All right. So if you didn't read the call here, you might think this was burglary. So as he was collecting valuables, he was surprised by the woman. He struck her on the head with a candlestick and tied her up, then finished filling his sack and left. So, all right, so he hit her, and then I'm like, all right, well, he hit her, so something else bad's going to happen. The police discovered the woman several hours later, which is great, and rushed her to the hospital. The defendant was apprehended by the police early the following morning with the loot still in his possession. So he still got it. He was taken to police headquarters, and he was given Miranda warnings. So he's given Miranda warnings. So after they give him that, if he chooses to talk, that's voluntary. So he can remain silent, or he can remain silent. He can also request an attorney, etc. All right, I have asked if he wished to make it. So then they ask him if he wishes to make a statement about the prior evening's events. So they ask him. So if he talks, that's voluntary. The police did not mention that the woman had been seriously injured and was in the hospital. They don't have to give him all the information. He's arrested, and then they ask him if he wants to talk about what happened the night before, which includes the burglary and him tying the woman up, and then what he stole. So they don't have to tell him all of the circumstances surrounding it. The defendant said he understood his rights and was willing to talk. Boom, that's voluntary. You're good to go. The confession comes in. He then admitted that he committed the burglary of the woman's house. All right, so they get a confession. The following day, the woman died from injuries caused by the blow to her head, so the defendant did it. The defendant was charged with murder. All right, so we knew that the question was about the confession, and the court is not going to grant it because they should deny the motion, so they should not grant it because the confession was legally obtained. Because he made a knowing and voluntary waiver of his right to remain silent. So I'm looking for something that says that. So A, no, because failure of the police to advise the defendant of the woman's condition was harmless error, since felony murder does not require intent to kill or injure. So one thing I want to say about this, so this is A is the right result, right? But this is a classic one where you're like, oh, wait, what about that? And like, if you don't know the answer, if you don't know exactly what you're looking for, like this is going to cause you maybe to pause and think. I don't know if that happened to any of you, but you're gonna be like, oh, well, does it matter? Like, should they have told him that the woman died? And you're like, yeah, well, that seems kind of unfair to this guy if they don't tell him that this woman has been seriously hurt. And it just like, maybe it seems a little bit unfair. I don't feel super bad for someone that did what he did, but you might think that's unfair. It doesn't matter though. So you have to know that it doesn't matter. So no, because failure of the police to advise the woman's condition was so that doesn't matter. So the fact, as soon as I see that, I'm like, this is incorrect. That's completely irrelevant. Also, the fact they say that it was harmless error, since felony murder does not require intent to kill or injure. I like all of that just doesn't really make sense either. He's charged with murder, so there is felony murder. It doesn't matter that it doesn't require intent to kill or injure. So A is just out for a variety of reasons. But it's one of those ones that I think makes people kind of go back and think about that and maybe talk themselves into picking a wrong answer. So then I saw B, no, because the defendant's waiver of his rights did not depend on the nature of the charges that were later filed against him. That's absolutely true. That's absolutely true. That's something that's more a Sixth Amendment thing, that you, if the defendant after the, Sixth Amendment right to counsel, that's offense specific, or offense specific. And if you choose to waive them, you waive them with respect to that particular offense. So you would need to know what you were being questioned about. So that's I think where people also might get tripped up. But B is the correct answer, because in this circumstance, before charges have been brought, you do have a right to an attorney and you have the right to remain silent. But B kind of gets at some of those other issues, and it's but here the waiver of his rights doesn't depend on which charges were filed. So C and D I know are incorrect, but let's look at them. So yes, because the defendant could not make a knowing and intelligent waiver unless he was informed concerning the woman's condition. That's just false. This also, I think, is kind of the trick. If it might also make you go back and think about that fact, especially because now you're seeing it again after you saw it in A, then you're like, oh God, maybe it should matter, but it doesn't. And then D, yes, because the use of a confession to burglary in a prosecution for murder violates due process, where the police withheld information about the potential seriousness of the offense. That's just incorrect. That just misstates the law. Then because they didn't have to tell him about the potential seriousness of the offense. They just have to say you're under arrest and you have the right to remain silent. All right. No, Miranda is not offense specific. And the Sixth Amendment right to counsel is offense specific. All right, question 4. To which crime is the pharmacist an accomplice? So when I see accomplice, when they ask that, I think, okay, what's the rule? So you have to have the intent. You have to have the specific intent to carry out the principal. That doesn't make sense what I wrote there, but you have to have intent required to be an accomplice. You must intend that the principal carry out the crime, the target offense. That's what I mean there. So. All right, so to which crime is the pharmacist an accomplice? So a husband decided to kill his wife, so the husband decides to kill his wife by poisoning her. So I'm like, okay, well then the pharmacist must also intend that the husband kill his wife. He asked a friend, a pharmacist, to obtain some deadly poison and to give it to him without recording the transaction, which seems shady. Because the pharmacist suspected the husband's motive, she supplied the husband with a small quantity of an antibiotic instead of the poison. All right, so she doesn't look like she suspects the motive, so she doesn't give him what he wants, but she lets him think that he's getting what he wants. So it doesn't look like she has the intent that he carry out the target offense, which is to kill the wife, so target offense of murder. So the antibiotic is harmless if administered in small quantities, except for the less than 1% of the population who are allergic to the drug. So obviously the woman's going to die from it. The husband injected his wife with the drug while she slept, and she died from an allergic reaction. Okay, so just because that happens, that doesn't mean that the pharmacist is an accomplice to anything, because the pharmacist did not have the specific intent for the husband to carry out the offense. So there's no degree of criminal homicide here. So D is the correct answer. A obviously is incorrect because there's no intent. B is incorrect. Also because there was no intent for the husband to effectuate a manslaughter. C is incorrect because you can't have the specific intent to do something that's negligent either. So C is incorrect. So D is our correct answer. Does that make sense to everybody? Okay, cool. All right, let's do question 5. Okay, so call a question. How should the court rule? I just look above, and what jumps out is double jeopardy grounds. So I'm like, all right, double jeopardy. Double jeopardy applies in criminal cases, doesn't apply to civil cases. So I'm just thinking, when does it attach? And I think and that varies between whether it's a bench trial or a jury trial. So you guys need to know the distinction between those two things. So for the and I actually don't recall that off the top of my head, but I think for one, it's when the first witness is sworn in. For the other one, it's once the jury is impaneled. I think it's once there's a jury, I think it's when they're impaneled, and if it's a bench trial, which is a judge trial, then it's once the first witness is sworn in. But you should know those rules because you will be tested on that. So I'm just thinking of all the rules that are related to double jeopardy. So those are kind of all swirling in my head. So a husband was arrested for domestic violence against his wife. So he's arrested. So there is a crime here. His wife agreed to testify against him. Shortly after the jury had been sworn in, but before any evidence could be presented, the couple reconciled and the wife refused to testify. All right, so the jury has been sworn in. So I think that's, and you guys should double check with the jury trial. I think that's when double jeopardy attaches. But you should double check that. Or if somebody wants to enlighten me now, that's fine. Believing the case was not strong without the wife's testimony, the prosecution dropped the charges and the husband was released. A few weeks later, the couple split up again, and the wife filed a battery action. So that's a civil suit for battery. So that's a tort claim for damages against her husband based on the original incident. It doesn't matter if double jeopardy is attached in a criminal case, you can still sue civilly. So the husband has filed a motion asking the court to dismiss the wife's case on double jeopardy grounds. How should the court rule? They should dismiss it because they should grant the husband's motion. And the reason is because let's see. Wait, hold on one second. I'm sorry. They should deny the motion because for B because it's an action for damages and not a criminal proceeding. So B is our correct answer here. Because that gets to exactly the point that I was looking for, which is that this is a civil case. This is a civil case. All right. So let's go through the other one. So deny the husband's motion because jeopardy had not yet attached during the first trial, since the prosecution had not yet presented any evidence against the defendant. And I think that I'll just look at this. Oh, I don't have the answer explanations open. I think that's the trick with this one. They're testing you. Do you know the distinction between a jury trial and a bench trial? So if you didn't know that, and you didn't know the civil rule, like some people might just jump to that because they see they focus on that negative, on that red herring at the beginning about how the jury's been impaneled, but they haven't called a first witness yet. So that's kind of getting at that point that I was mentioning. So for A. But A is incorrect. B, deny the husband's motion because it's an action for damages and not a criminal proceeding. So that gets to exactly I've said it doesn't matter because it's a civil case, so there's no double jeopardy. So B is correct at saying what I thought, but just slightly different phrasing. C is the incorrect result. So grant the husband's motion. So that's the incorrect result. Because battery is a lesser included offense of domestic violence. It's not. This is a tort claim versus a criminal charge. Those two things are unrelated. And then D, grant the husband's motion because the prior case was not discontinued due to a manifest necessity. So that's testing you on the rule of double jeopardy doesn't attach if a case is declared a mistrial or something, or a trial is discontinued due to a manifest necessity. So that's testing you on yet a different rule. So it should sound familiar, the phrasing manifest necessity, but it doesn't apply in this case. So B is the correct answer. But this question does demonstrate well how a couple of things. So it shows you how with 4 different answer options, it can test you on 4 different rules at the same time. So they do that with this question. Also, this is one where if you didn't read, and I made the note here on the side, that if you didn't read the call of the question and know that they were dealing with, like, if you look above and you see the double jeopardy, then you would start thinking that this was an evidence fact pattern, because they will test this. They will use this very similar fact pattern for evidence, and they will use it, but they will make it, and they've done this in an essay too, where they're testing the spousal communication privilege and marital communication privilege. And that's how they'll do it. They'll have people, there'll be a domestic violence case, wife agrees to testify, but then it's exactly the same. It might be like there was a recess and they reconcile over the recess, and now the wife refuses to testify, and it's, can she do that? Or, the prosecution might force her to testify. Like, that's a classic evidence fact pattern. So don't get tripped up by that. So B is the correct answer here. Let me just highlight that. All right. Question 6, is the court likely to agree? So suppressed on Fourth Amendment grounds. So I look directly above, and so I know, again, I'm in Crim Pro. And remember that with Crim and Crim Pro, half the questions are on Crim, half the questions are on Crim Pro. All right, so police investigating a homicide had probable cause to believe that the defendant had committed it. So they have probable cause. They then learned from a reliable informant that a short while ago, the defendant had gone to a friend's house to obtain a false driver's license from the friend, a convicted forger. So they're going to a friend's house. So as soon as I see a house, I'm thinking, and then I saw that it was Fourth Amendment, I'm thinking search and seizure. And this is the defendant, but the defendant is at a friend's house. The defendant does not have a reasonable expectation of privacy at the friend's house. So I know that there's that issue. So believing that the defendant might still be there, the police, without obtaining a warrant, so they're telling you that they don't have a warrant, so you'd have to have an exception, went to the friend's house. So they're trying to, like, tell you, like, hey, this is a warrant violation, it's a Fourth Amendment violation. They entered the house and found the defendant hiding in the basement. He was arrested and given his Miranda warnings, and then at the police station, he confessed to the homicide. So there, I also noticed, okay, well, he's at the police station, and it's not like they found something with respect to the search. They found him, right? But that's it. And then later, he chooses to talk. the fact that they arrested him, like that's at his friend's house, is unrelated to the fact that he made a confession. So for that reason, also the confession should come in because it's not fruit of the poisonous tree of the search because he chose to voluntarily, like the defendant chose to talk. So there's two reasons here that he can't have it suppressed. So A, he didn't have a reasonable expectation of privacy, and B, he chose to talk. He waived his rights, and that's not fruit of the poisonous tree of the illegal search. Does that make sense? Do you guys see that? All right. So at a preliminary hearing, the defendant's attorney contends that the confession should be suppressed on Fourth Amendment grounds. So is the court likely to agree? And they're not. So let's go through these. So D is the correct answer. No, because the police had probable cause to arrest the defendant, and they did. So they had probable cause to arrest him. After you have probable cause to arrest someone, you can you can detain them, and you can question them, which is what they did here. So they had probable cause, and they properly obtained a confession. So D is correct. Also, there's no standing to assert that there was a Fourth Amendment violation with respect to being in the house. So let's go through the others. So A, yes, because the police did not have a search warrant to enter the friend's house and there were no exigent circumstances. Can't use that because he doesn't have a reasonable expectation of privacy for the warrant. So A is out. Yes, because the police did not have an arrest warrant for the defendant and there were no exigent circumstances. Doesn't matter that they didn't have an arrest warrant because they had probable cause. So B is out. C, no, because a reliable informant told police that the defendant was in the friend's house. That also doesn't matter. For the reasons that I've already stated, he doesn't have standing to assert that, and the informant is pretty irrelevant here. And also, they obtained the confession properly. So, and then D is our correct answer. Any questions about that? Okay, good. Okay. So, question 7. So, which of the following best describes the situation? So as soon as I see this, I'm like, I don't, and it's all one big block. So it's the officer immediately arrested the man. I look above and it doesn't give me any help. So I'm just going to go to the fact pattern. So a police officer spent several hours using binoculars to observe an older man loitering on a college campus. And I see binoculars and I'm thinking, okay, search, but that's like technology that's readily available. So that's okay. It's also in a public place. The man, who was showily dressed and carrying a backpack, would approach certain students as they walked by him, and after a brief conversation with them, discreetly pass the students a small envelope in exchange for cash. So I'm like, all right, that looks a little shady. So I think he can probably go over and talk to the guy, find out what he's doing, because he probably has. He could do a little Terry stop here. The officer stopped the man under suspicion that he was dealing drugs. So that's why he stops him, because he wants to see if he's dealing drugs. The man was not dealing drugs, but instead had been soliciting donations for a radical political group. That's not illegal. He can do that, and at that, once the officer finds that out, he can't do anything else. His reasonable suspicion is gone, and officer can't proceed. The man grew irate when the officer opened one of the envelopes in question and discovered that they only contained literature about the group. All right. So now the officer absolutely knows that there's no drug dealing going on here. And the officer has to stop and let the man go. But the officer then frisked the man and discovered an illegal weapon taped to his leg. Can't do that search. Can't do a pat down like that. Even if it was like the type of pat down he did, because it was a pat down and you can't like do any squeezing of anything. That was okay. But the pat down in and of itself is illegal because his reasonable suspicion is gone. The officer immediately arrested the man. So which of the following best describes it? So I'm just going to go through. So C is the correct answer. So I'm looking for one that talks about that the officer was incorrect. So the officer's actions were lawful in stopping the man because the officer had a reasonable ground to believe that the man was dealing drugs. But the subsequent search was unlawful once the officer realized his mistake about the drug dealing, and that's absolutely correct. He could talk to the guy, but once he realizes there's no crime, there's no criminal activity afoot, you got to let the person go. And that's what the officer did wrong. So C is correct, but let's look at the others. So the officer's actions were unlawful because the officer initially failed to get an arrest warrant before approaching the man. You don't need to do that. You don't need to do that, even though he had ample time to do so because the surveillance had been going on for several hours. That's just that's not true. So A is incorrect. You can approach someone without having an arrest warrant as long as you have reasonable belief that criminal activity is afoot. That's classic Terry stop. So that's why it is incorrect. So B, the man's arrest was unlawful because the arrest was unlawful because the officer was mistaken about the man selling drugs, and thus the weapon would be inadmissible as fruit of the poisonous tree. Um, that is incorrect. It's fruit of the poisonous tree. Why is it not fruit of the poisonous tree? Hold on, let me just double check the answer here. I knew this before we started. Now I forgot. Oh yeah, okay, that's why. Yeah, so it says here if during an investigatory detention, which is what was happening here, the officer develops probable cause, the officer can proceed. So he was incorrect initially, um, but the illegal weapon was sufficient to establish probable cause for the man's arrest. So what that's essentially saying is that um, this really isn't getting to the search at all. So and the search was improper. So that's why B is incorrect. So C, the officer's actions were lawful, but that one is the correct one. And then D here it says the stop, search, and subsequent arrest were lawful, and that's incorrect. The search was unlawful, so we know that. All right, any questions about that one? Okay. All right, let's look at question 8. So what is the best defense raised by the defendant's testimony? I look above, it doesn't really give me anything. So I'm going to but I'm looking for a best defense. And I know often when they ask me for the best defense, that it's not even a great defense. But so just always keep that in mind that there's going to be 3 that are absolutely not possible. There's going to be 3 that are not possible, but um, and then 1, and even if it's not a great defense, it's still a plausible defense. All right, so a defendant who had been previously hospitalized at a mental institution, that's the fact that they use to tell you that the insanity defense is coming, was charged with the murder of his wife. In his defense, he testified that at the time he killed her, he believed that his wife was planning to destroy the world by detonating a massive explosive device that she had developed and built in the basement of their home. So it seems like he still is not mentally all there. So you're probably going to look for an insanity defense. He also said that he had concluded that the only way to prevent her scheme was to kill her. So he wants to kill her. So he has the requisite mens rea, which is the mental state required. Um, so, uh, and that he becomes so obsessed with the importance of doing so that he could think of nothing else. So that also goes to his mental state, that he only wants to kill her, and that also seems a little bit insane. One day when he saw her open the door to the basement, he lunged at her and pushed her down the steps to her death. So he had the intent to kill, and then he acted upon that intent. So we're looking for something that we're looking for a defense here. So A, lack of the requisite mental intent. That is incorrect because he did have the requisite mental intent. Um, he had intent to kill and he carried it out. So A is incorrect. B, lack of the requisite act element. That's incorrect because he lunged at her, pushed her down the steps to her death. So he intended to do that. C is insanity. So that's under any of the tests, insanity would work here. So he can raise that defense. So, and you want to think of, remember that there's the 3 insanity defenses. There's, I think, ALI, American Law Institute. There's M. Naughton, and there's the MPC. And make sure that you know all 3 of those tests. You will need it for at least, a couple of MBE questions, at least one, but maybe a little bit more, and they're not that difficult. Or D, belief that the situation justified his actions. That's incorrect. There are a few justifications or justified killings, but this is not one of them. This is classic insanity. So this is excuse versus justification is what they're testing here. Do you know the difference? So insanity might excuse what you did. And then a killing, you might have a reason that you were able to kill, and that justified your action. So you weren't crazy, but there was some more extreme circumstance. So that's kind of getting at the difference between those 2 things. But C is the correct answer here. Any questions about that? Okay. All right, number 9. Should the defendant be found guilty? So I know I'm in crim here. A defendant was owed $500 by his bookie. The defendant went to the bookie's house one night to get his money. So as soon as I see that he's going to somebody's house, I'm thinking burglary. But you have to have the intent to commit a felony once you enter. The bar examiners will do this. They will have a fact pattern like this where if you are going to recover something that is your own, that is not technically committing a crime. And remember that he has to have the intent to commit a crime at the time that he enters under the common law. So the defendant opened an unlocked window and entered the house. So he opened a window, so there's a breaking, and then he enters the house. There's an entry to see if he could find the $500 due him. So they're pointing out that that money is supposed to be his. He could not find the cash, so he decided to take a painting that he knew was worth substantially more than $500. So now he's taking stuff that doesn't belong to him. He later sold it for $1,000 and kept the proceeds. The defendant's charged with burglary, but he didn't have the intent to commit a felony at the time of entry, so he's not liable for burglary. The jurisdiction in which the bookie's house is located retains the common law requirements for burglary, so this isn't a burglary. So should he be found guilty? It's no. And the reason is because when I look at this, as soon as I saw this and it was burglary, I would probably write down the elements next to the question, and I would see which ones are present. There's breaking, entering, it's a dwelling house, it's of another, and it's at night. So the only one that is at issue is intent to commit a felony therein, and I know that has to be at the time of the breaking and entering. And that's not there. So it's no because he didn't have the intent at the time, which is answer B. And that is the correct answer. So A, no, because there was no breaking since he did not use force. You don't have to use force. You just have to open or enlarge something. And he opened an unlocked window. So because he opened it, that's a breaking. C, yes, because he did have the intent to commit a felony when he entered the house. So that is, he didn't have the intent to commit a felony. That you have to know that distinction. And when they tell you that it's something that he owns, if I'm going to get something that I own, then it's not considered a felony under the common law. Some jurisdictions have eliminated that rule today. Not all, but some have. So, although on a burglary question, if you're given burglary, you would talk about burglary and modern law, but you actually don't say that they've eliminated that requirement. So, the general rule is burglary is a breaking and entering the dwelling house of another at night with intent to commit a felony therein. And under modern law, they've eliminated the nighttime and the dwelling requirements. And then there are some jurisdictions that have also eliminated this coupling of the intent and the breaking and entering, but you can leave that last part off. All right. So C is incorrect. And then D, yes, because the painting was worth substantially more than $500. That doesn't matter at all. It doesn't matter because he's taking the painting, which he knows doesn't belong to him. So that would be, so he can't do that. But he also lacked the intent at the time that he broke and entered. So so B is our correct answer. Any questions about that? All right, so question 10. So if the jury believes the hiker, what is the most likely verdict? And this is kind of a classic question that a lot of people just don't know. This is like a bar rule. So let's look at this. So while hiking through an area that had been recently devastated by a fire, a hiker discovered a sign that stated, "Now entering state wilderness area." So that obviously doesn't belong to him, and it's a sign that's entering property of another, the state wilderness, the state. So that sign probably belongs to the state. Thinking that the sign would make a nice decoration, the hiker took the sign home with him. He was arrested and charged with violating a state statute that provides, "Any person who appropriates to his own use property owned by the state shall be guilty of a crime." So there is this statute, and this is a statute that you don't know. But if it's a statute that looks like another crime, then you should apply the rules of that crime. So here, this looks like the crime of larceny, which is essentially what they're getting at, but it's larceny against the state. So at trial, the hiker admitted taking the sign, but claimed that he believed the sign had been abandoned. So if you think that something's been abandoned, that means that nobody else owns it. So you wouldn't be committing larceny or violating this crime because you're not taking property of another. So he's not taking property owned by the state. So he believed the sign had been abandoned, given that the area had recently been devastated by a fire. In fact, the sign had not been abandoned. So, all right. So if the jury believes the hiker, what is the most likely verdict? and not guilty because he honestly believed that the sign had been abandoned. So the jury believes him, and the jury believes him, and he does believe this. So D is the correct answer. So A, guilty because it's a strict liability offense. That's not true. It's not. This looks like larceny, and you have to have the intent to take property of another. And he didn't here. So B, guilty because intent is not placed in issue by this statute. So that's probably the trick here. But you do have to intend to take property. You do have to take property that belongs to somebody else. So there is an intent component to that. C, not guilty as long as the jury finds that the hiker's belief as to the sign's abandonment was reasonable. That's incorrect. You're looking at what the particular defendant thought. So don't tie in tort principles here. And then D, not guilty because the hiker honestly believed the sign had been abandoned. That's a correct answer. All right, any questions about that? No, okay. Yeah, I will. And I did. I think that I've posted all of them. The only ones that I think, so Sarah asked if I could post a question with my highlights. And yeah, I absolutely will. I think that I actually saved these already. I did lose one set because my whole computer crashed, but for the Civ Pro comments, but the rest of them are posted. But let me, oops, I will save these right now. Desktop. Okay. Oh, okay. I'll double check too. Sorry, there's two twin pages, so sometimes like I'll think that I've uploaded everything and I haven't. So that's part of the reason why. But yeah, I will go back and I'll double check because I was looking at that. I was looking over that stuff earlier today. All right, so now I'm gonna give you guys 30 minutes and I want you to do that. Actually, let's look to see what the problems are. Crim Pro. One of these is Crim and one's Crim Pro. Okay. Okay, so generally speaking, when the bar examiners test um, Crim or Crim Pro, it's more likely that it's Crim Pro, which is the one that's labeled Crim Pro 1, but it says question 3 at the top. So I think we should definitely start with that one, and then if we have time, we'll go into the second one, which is a murder and attempt question. So I will give you 30 minutes. So we'll reconvene at 7:45. And I'm going to mute my mic so you guys don't hear me talking to my dog. All right, you guys ready to get back started? Let me just get the fact pattern back up here. Okay. All right, cool. Okay. Let me get now my documents. Sorry, I got to get my documents up here. All right, so let's. Okay. All right, so the first thing we're going to do is we're going to read the call of the question. It says, how should the court rule on each point? If that doesn't give you what you're looking for, if it doesn't tell you what subject you're in, then you should look at the paragraph immediately above to figure out what paragraph you're in, because that's going to be probably more informative than going through the fact pattern and trying to figure it out. So here it says, Dora has moved to suppress evidence of 1, the drug detection dog's reaction, 2, the small box, and 3, the overheard conversation under the 4th Amendment to the U.S. Constitution. So, all right, so I know I'm in Crim Pro based on that because she's moving to suppress evidence. So I will make my list A, which I've done on the right here. So for Crim Pro, for me, and again, this might change for you guys. So you guys need to make a list A that's good for you, that hits all the subjects, or hits all the issues that are, it hits all the issues for whatever subject you're in or whatever subjects you're in. So I just says 4th, 5th, 6th, and 8th Amendment. The big A means amendment to me, so I do that in common law as well. And then I would think, okay, fruit of the poisonous tree and the exclusionary rule. So I'm thinking of all of those things. So, whatever your list A looks like, it can be completely different from mine. It doesn't matter. It can be more detailed or less. You just want to make sure that it does trigger all those things in your mind about what you need to discuss for that subject. So then once I read that, then I'm going to go through and I'm going to read the fact pattern to identify the issues. So Owen, a police officer, had a hunch. So he has a hunch, which isn't a reasonable suspicion or probable cause, that Dora might be selling methamphetamine from her house in the country. Okay, so it's in the country, so they're telling us that for a reason. To learn more, Owen drove to Dora's house with a drug detection dog and waited until she left. So I'm like, all right, it's a drug detection dog. It's going to have the dog sniff, which is probably not going to be okay. And I know that the question said the drug detection dog's reaction. So Owen first walked the drug detection dog around Dora's house. So he walks it around her house. So, which is, you're thinking, okay, well, is that okay? Is that a search or not? At his direction, and you have to know too that a dog is the agent of the officer. At his direction, the dog jumped on the porch, sniffed the front door, and indicated the presence of meth. So the question there is that a search? So I know I'm in 4th Amendment. Is there a search? If there is there, do they have a warrant? He doesn't have a warrant. He doesn't even have probable cause because he has a hunch. And does she have a reasonable expectation of privacy, even though it's on her porch? And I think this is debatable. Even though it's on her porch, I'm thinking, well, you allow people to come to the porch so they can come see you. You don't allow them to bring a drug sniff dog and then have that dog sniff based on that. So that seems like kind of going beyond what people allow someone on the porch for. So I think that's problematic, but that is probably going to be a little bit, there's going to be some arguments on both sides there. So I'm like, all right, that's all 4th Amendment. Owen then propped a ladder on the back of the house, climbed to the top, and peered into a 2nd-story bedroom window. So you're on the 2nd floor. So then I'm like, all right, well, that's a search. He's looking through a 2nd-story bedroom window. So there is a search there because on the 2nd floor, you have a reasonable expectation of privacy. And even if you can peer inside, so you might think that you don't have a reasonable expectation if you leave your window open. It's on the 2nd floor, and he had to put a ladder up to get to it. So I'm like, all right, here's another search. He saw a small box on a bedside table, but could not read the label. So, okay, then he uses binoculars. Okay, well, using binoculars is different. There's the case law on that point that talks about what kind of tech an officer can use. Binoculars are readily available, so I think that's okay, but it's only okay if you're legally there. So then I'm thinking, okay, well, you can use the binoculars to read the label, saw that it listed ingredients that could be used to make meth. So, there's the small box. So I'm thinking, okay, well, if, should this be excluded? Is this fruit of the poisonous tree? Is it fruit of the product of an illegal search? And it is, or I think that it looks that way, then it's going to be barred under the exclusionary rule. So there's that. And then the next paragraph 4. Owen went back to his car, saw Dora return home, and then walked back to the house and crouched under an open window. So now he walked back to the house and crouched under an open window. So it's an open window. So if you have an open window and you're having a conversation and people can hear it outside, then you don't have a reasonable expectation of privacy in that. So he soon overheard Dora telling a telephone caller, "I can sell you several ounces of methamphetamine." But remember at the beginning they said that she was at her house in the country. So it's not like a house in the city where you expect people are going to be walking around and paying attention to you, or can hear you readily, and especially too because he's crouching down. So you have an open window, but you're out in the country, which suggests that you're not going to have anybody. There's not going to be sidewalks. There's not going to be houses nearby. So I think that's also ambiguous, because and remember you've got to use every fact here. So, and that's why they're telling us that house is in the country. So, all right. So then based on that, then I make my list B. So I'm making a list of all of the issues, and this is really nice and something to see. So at the outset, they tell you that they give you a little bit of background facts, and then each paragraph preceding or following that is about one piece of evidence by themselves. So they break it up for you. So they're giving you all the facts related to each one for the most part within paragraphs 2, 3, and 4, which relates to evidence pieces 1, 2, 3, which is really nice. So they kind of organize it for you. And then but you got to remember to use those paragraphs, the facts in the first paragraph as well. So we want to find a home for every single fact. So I make my list B for each one. So I'm thinking, okay, this is all Fourth Amendment. And we knew that from the call. It's under the Fourth Amendment of the United States Constitution. So based on that, actually, I actually read that too quickly. I just knew Crim Pro, so I wanted to list out my whole Crim Pro list A, and I also like to give you guys my whole Crim Pro list A. But actually, because it's under the Fourth Amendment, I probably would have listed some of those issues that were just directly related to the Fourth Amendment. So you can do that as well. All right, so for my list B, that I'm going through Fourth Amendment. So going through Fourth Amendment, and I'm like, all right, well, for Crim Pro, you have to have government conduct. And then I'm thinking, okay, is it a search? So it's really search and seizure, Fourth Amendment. So if it's a search, you have to have a reasonable expectation of privacy, and there has to actually be some sort of physical intrusion generally. And then you also have to have a warrant or an exception to the warrant requirement. Then there's also the exclusionary rule and fruit of the poisonous tree. All right, so then I'm going to go back and I'm going to match up my facts. So I've read it once, I've made my list B, then I'm going to go back and I'm going to match up my facts as well. So, and I might also highlight my facts as I use them because I want to make sure that I'm using every single fact. And I haven't done this before with you guys, so I wanted to show you here as well. So, okay, so government conduct, so I'm going to start there. And I'm going to do this in a different color. Can you guys all see my screen okay? Can you read it okay? I'm assuming yes. Okay, cool, thanks. All right, so government conduct, this is Owen is an officer. He's an officer. So search. So for a search, let me show you I have an answer to this one. So a search implicates the Fourth Amendment if a government agent searches a constitutionally protected area in which the individual has a reasonable expectation of privacy, or if you enter, if a government agent effects a physical intrusion into a constitutionally protected area. So I'm looking at both of those things. So you just need to have one. Especially if there's 3 pieces of evidence like this, I might do this a little bit differently. I'm listing kind of everything possible here, but I might eliminate the search heading and eliminate the physical intrusion heading and just do a reasonable expectation of privacy heading. So, but that's kind of up to you. You've got to see different fact patterns. But I will generally often just do reasonable expectation of privacy. So here, so this is we're in the porch. So we're in the porch. So the facts here, it's a drug detection dog. Dog jumped on porch, sniffed the front door, indicated of meth. So So I'm listing my facts here, and then I also do, so I'm going to do my conclusion, which I do in red. So yes, search because, and I just want to, and you guys can do this in shorthand, so don't think you have to write all this out, but I would say yes, search because goes beyond what people invite someone onto porch for. So, and then I put a counter, I put asterisk because that's my symbol to myself that I need to include a counter argument. Say, although porch is public, this violates public is permitting to knock on door to talk to owner, not search for drugs. Okay, so that's what I would put. So I'm gonna list all those facts here. I'm gonna list all of those facts here. Yeah, this is where you would discuss curtilage. This is also where I think you also do that on the yeah, you would discuss curtilage here, yes. And you would also do that for the part where he's overhearing the conversation because he's right, he's like right on the curtilage of her house there as well. Okay, so reasonable expectation of privacy. Okay, so then has there been some sort of a physical intrusion? Let me just pull this back up. Yeah, so the physical intrusion into a protected area. Yeah, within the curtilage. Sarah, I just wanted to double check here too that I do discuss the curtilage. So physical intrusion. I'll just say yes because officer directed dog to jump on porch. And then I'm just going to put like quote marks, and that refers me to what's directly above. I'm going to probably use some of those other facts as well. And then I'm going to make a note here. There was no warrant, and I'm running through all the all of the exceptions in my head. So, and you might have listed those at the top two in your list A, but like I know them. So, is it, Terry stop, checkpoint, plain view, etc. So you would go through all of those and see, and I know on this one that there isn't anything that applies here. And then, so I'm just going to, no exception. Oops. No exception applies. And then it's, so violation of warrant requirement. Or you could just do violation. So per the exclusionary rule, then court will exclude. So then, and I would make my notes up here. So government conduct. And then at the very top, because the court, how should the court rule on each point? I'm going to put my conclusion at the top too. That court should grant motion. So I put my conclusion there. All right. Next one, the small box. So and also let's look at this. So I'm going to highlight. Walk the drug detection dog around Dora's house. So I didn't. So and I just noticed this. So this is why I do this. So I'm going to highlight the facts that I've used. So at his direction, dog jumped on the porch. Oops. Sniffed the front door and indicated the presence of methamphetamine. So I'm going to use all those facts. But as I did that, like you'll notice that I said, and first walked the drug detection dog around Dora's house. So I'm like, I haven't used that fact yet. So where does that fit in? Where does that fit in? So I'm like, okay, well, I like at that point, I don't think that there's necessarily a search. And they're asking specifically about the dog's reaction. they're asking about the dog's reaction. So I don't know where I would use that. Maybe just talking about the curtilage, and that it wasn't bad at that point. Because maybe the lack of a reaction is there. So porch, and then I'm going to say reasonable expectation of privacy. So I'm going to add that. So walked dog around house, which I think is curtilage, right? I hadn't actually thought about that, so this comes up. So this is what you kind of want to do. This is why you want to go back and check and make sure that you've used every fact. So yeah, the porch was outside the curtilage. Attached to his dwelling. Yeah, so I would say walked around the house, but didn't alert. So, which was not a search, but the search of the porch is, and they're asking specifically about that. So I'm like, all right, well, I figured out a spot for this, and maybe I'll think about, and as I'm noticing that, like the whole time I'm processing, well, what is that? Why is that fact there? Yeah, making it an open field. Yeah, maybe that's a good point. So yeah, Adam mentioned that walking around the house shows that anybody could walk around it, so making it an open field. Yeah, I think that's a good point. I think that's a good point. So you could use it for that. All right. So then let's look at the next one. So Owen then propped a ladder on the back of the house, climbed to the top, and peered into a second-story bedroom window. So here I'm like, all right, so my little note, I'm going to put the double quote marks. Yes, it's government conduct. Has them going to search. So did she have a reasonable expectation of privacy? So then I'm going to look at that. So second story. Back of the house. Propped a ladder to see. He propped a ladder to see. And then he peered into, but it appears as though you could easily see inside. Which equals possible plain view. So I'll discuss that below. So here she does have reasonable expectation of privacy because yeah, so I'm actually going to delete that because that could easily see inside, but can't generally see inside top second story. So there's an issue. And then I'm thinking, okay, well, you can make the argument that the plain view exception would apply, but the fact that, let's see. Oh, yeah, I couldn't see when you walked around the house. Yep, there you go. That's a good call. Couldn't see inside the second story. Yeah, so good call, Adam. And couldn't see the box when walking around the house. Good. So reasonable expectation of privacy. So warrant, so plain view, so could see when propped ladder. So no blinds to keep to prevent people from seeing inside. But second story and didn't see when first walked around the house. Good. So that's good too. So then I'm going to conclude that the plain view does not apply. So no plain view. So then but I'm also going to say but used binoculars, which are readily available. So, okay. And that's going to be a counter argument. We're talking about the use of the binoculars and how that's generally tech that's found around. So, and then I'm going to say, okay, so based on the exclusionary rule, anything obtained in violation of somebody's constitutional rights has to be excluded. And here, because there's no exception to the warrant requirement. So here, so this is like kind of two level. I should actually talk about the fruit of the poisonous tree and exclusionary rule are really closely related. Without the ladder to the second story, the binoculars be canceled out. It wouldn't have seen the box without the ladder to the second story. So this is kind of gets into this, Andrea, that you're asking about. So the search here, like you could say that the plain view doctrine applies because they were in plain view when using binoculars. That's okay, but they are fruit of the, so they should be excluded under the exclusionary rule based on that. But it's fruit of the poisonous tree of using the it's not plain view because you couldn't see it from somewhere somebody else could see it. So because you had to use the ladder. Yeah. So it's sort of like it's like multi-layered here. Exclusionary rule. So I would say, yeah, that it's plain view just using the binoculars, but so just under that you might not, but with fruit, it's fruit of the poisonous tree of the unlawful search because you use the ladder. Okay. Use ladder. And then fruit of poisonous. Yes. Actually, it's just be. Ladder. Okay. So government conduct's a small box. So what should the court do? The court should grant motion. Okay, and then what about the overheard conversation? So the overheard conversation. So again, we have the same issues, but this one is a little bit different because it's a little bit different because that one she's talking with a and there's the window appears to be open, or I think it says that. Yeah, I've crouched under an open window. So all right, so government conduct, same thing. So reasonable expectation of privacy. So that is a little bit trickier here. Oh, sorry. Oh. Let's actually go back and just highlight the facts and make sure that we used all of them in that last call. And then propped a ladder on the back of the house. So you might also say, okay, so it's the back of the house. So you don't expect somebody to be able to see it like from the porch. So there's probably not going to be a street nearby and it's in the country. So I'm like, oh, okay, well, so can't readily see in and probably no streets. No streets or sidewalks because in the country. So I'm going to add that to, I'm like, oh, so like when I go back and do this highlighting and I'm checking everything, then I start to see more arguments. And it happens again here. We're at a house in the country. Okay, so climb to the top. So he climbs to the top of the ladder. And peered into a second story bedroom window, saw a small box. Could see, okay. Let me see. Okay, yeah. So saw, sorry, my highlighter isn't the best thing here. Saw a small box on a bedside table. That also tells you, so the fact that it's, here, let's do that. So saw a small box, but it's on a bedside table. So you really think that like that, so it's in a bedroom. So then you're like, oh, okay, so you really do have an expectation of privacy because it's in a bedroom. So I'm going to add those facts in here. So I want to make sure that I'm using that. So on a bedside table tells me that, so it's in a bedroom. and people expect privacy. So that's another thing. So you want to make sure, like, you're not just using every sentence, like every fact on a bedside table. Okay, use binoculars because, and then I'm gonna say, okay, because could not read label. Okay, could not read the label. It used binoculars to read the label. Which are readily available, so that's okay. And saw that it listed ingredients to make meth. All right. So do you see why going back through the facts is really helpful? Because then I'm starting to see other arguments and other issues that are in here. In fact, and I also realized that I haven't talked about the fact that he has a hunch. That he has a hunch. So warrant exception. All right. So then I'm going to look, okay, at the third one. So paragraph 4. So Owen went back to his car. He went back to his car. Saw Dora return home. Saw Dora return home and then walked back to the house and crouched under an open window. Okay, so reasonable expectation of privacy. So it's an open window. Open window. But the fact that Owen could see Dora return home from his car maybe alerted Dee that someone was nearby. So I'm like, okay, well, maybe that goes against her having a reasonable expectation of privacy then. And to close window. So I'm thinking about that. And he's also, so he's back at his car, and then he sees her, so then he crouched under window. So O is not visible to D. And D lives in the country and doesn't expect people to be nearby. So I think this is ambiguous. So I think this is a little ambiguous. So here, you like this one, you definitely need to raise some counter arguments, and like you can see them as I'm going through. That I have one for each issue here, and it's all under reasonable expectation of privacy. So there is no warrant. There is no warrant. And then I'm thinking, okay, well, plain view, which is also like plain hearing. Plain view extends to that. And open window, so anyone could hear, but in the country. Okay. So then I'm like, all right, well, do we have to exclude this? So is there a search? Does she have reasonable expectation of privacy? I think that's ambiguous. I think it could really go either way. I actually kind of think that she does have reasonable expectation of privacy, but I really think you could go either way. So I'm just going to have a conclusion and raise my counter argument, and you would be fine on this one. So I'm going to say that she does have REOP, so it's a violation, and the court will exclude under the exclusionary rule. Oops. And then I'm going to say the court should grant the motion. So do you see how kind of going through that process? And then now I've gone through it. I'm going to double check my facts. Okay, so went back to his car, saw Dora return home, and then walked back to the house and crouched. I haven't actually used the fact that he walked back to the house. So, that tells you that, where he's in it. So he's in the curtilage. So walked because back the curtilage is like the areas right around the house, right? So, so within curtilage, so it's open. Owen can see door, return home from the car. So I'm using that fact. So you see here, like going through, you will, yeah, you could, I mean, you could show there's no exception here. Like I'm going to say like there aren't any. There's nothing to suggest that it's an exigent circumstance. But I'm not going to go into that. I'm not going to go into each one. So walked back to the house. Well, I guess the fact that he walked, and he crouched, and then he overheard, a window, crouch in the window. Overheard. Although I knew this one, D telling, I can sell you several pieces of meth. Oh, he had time to call for a warrant. Yeah, that's true. I think that's a good call. So he could have obtained a warrant. Yeah, no warrant, but had time to obtain one. Yeah, good call. Telling a telephone caller, I can sell you several ounces of meth. And then she's arrested and charged with attempting to sell methamphetamine. So I've used, and then I'm gonna go back and just check the rest of it. If I use these facts, had a hunch that Dora might be selling. So no warrant, and no reasonable or no and no probable cause or reasonable belief. So that applies to all of them. Had a hunch. He drove to Dora's house. So I guess he had to drive there, but that's not that. So he drove to Dora's house with a drug detection dog and waited. Oh, and he waited, and so then there's that fact. So he brought a drug dog to do this, and then waited until she left. So she does have an so the fact that he waits until she left, I don't know. You guys can figure out where to place that, or where do you guys think that should go? Waited until she left. So he's trying to do it without her permission. Like I guess she's gone. So he's trying to do this search without her knowing about it. So she can't give permission. So I would actually probably use that for the dog sniff. Direct a dog to dump on porch, and waited for D to leave before he walked dog around house. No, we're not searching for more facts. So what I'm doing is I'm going back to make sure that I used every single fact, because every fact is in there for a reason. So I just want to find a home for everything. So that's why I'm doing this. I'm going back and I'm checking to make sure that I've used every single fact that's in here. And now I have. Because if you don't use a fact, then you're not using it. You're not making the strongest possible arguments. And that's what you guys want to do here. Generally speaking, to do well, you need to, and you do need to use every fact. And it might be okay on an essay here and there to not use every fact, but like that's not going to be a high scoring essay. So that's why I want to go back and check. And you do have time to go back and do that. So I've spent, at his direction, I did do that. I did use that one. So we started at 45. It's been 30 minutes, and I'm going through here and I'm typing out way more than I would type out. I would type this shorthand, or I would write it shorthand. I'm also obviously talking about it. I'm reading. I'm like doing highlighting on a computer, which is obviously taking me a lot longer than it would just with pen and paper. So in reality, this would have taken me 20 minutes, but I've got everything written out. I've got my notes on all of it. I know it, and now I can spend 40 minutes just typing everything. Like I've already kind of thought through, and I'm like, oh gosh, like is that like what's the deal with that? And where can I use my counter arguments? I know that each of these are pretty well split up. That I'm probably going to spend the same amount of time on each. So it's probably a little less. It's like 12 minutes, 13 minutes on each one. So a little bit longer on the first because I'm typing out the rules, and then I'm going through, and then I can just do see rule above for the others. And I can also, see analysis above that it's government conduct, like that I could do as well. I could do explain why. Uh, you could say explain that the same analysis applies because it's the same officer doing everything here. But that would have taken me about 20 minutes. Then I've got 40 minutes, and I can just type all of this out. And I've got all my conclusions. I know how I'm going to just come out. I know what the court should rule on each, and I've literally used every single fact. So do you see how, like, even though, so does that make sense? Like, that's why we pre-write, is to go through this. And that's why we got to double check that we make sure we use all the facts. Any questions? Yeah, do you guys, because I do want you guys to pre-write. Like, I want you to go through this process when you're on it. Especially now, like, you guys have the mock I think a lot of you have, if you're taking Barbary, you have their mock MBE, I think, coming up tomorrow. And then um, next weekend, I think you have the TJSL mock bar. For those of you in CBC, I think that I might have put dates. I also, privately, I do a mock bar. Um, and mine is this weekend for those students. Um, so if you have the CBC schedule, you just need to switch the 2 weekends around, I think. So you should just double check that. Um, but I want you guys to practice this, and like, I like to do this so you can see it and do it with a time allotment, and look at how much time. And you guys you absolutely, even if it did take me 30 minutes, I could spend 10 minutes on each of these and I would be fine. Um, 40 minutes is better because you can make sure you get all of it. I might be a little stressed with only 30, but going through this process, like the schools that do this, like the students that do this, like they, I know, like, that this works. Like, I've seen it because the pass rates are really high. And this process, like, specifically is very deeply ingrained. So just don't fall into the thing where you don't want to spend the time, or you get scared because everybody else in the room has started typing. Like, trust, like, you don't, the thing you can't hear when everybody else starts typing is you can't hear how often they stop and pause and think about it because they haven't thought through the problem yet. And you've got to avoid that. So we've done all that at the outset here. All right. Any questions? I already asked that, but all right. So we don't have time to go through another one, the second one, but that one's just straight crim, and it's homicide, and attempt, and it's I think that it could happen, but it's not. You should definitely practice it, but people are generally more comfortable with, I think, crim. The recorded workshop for tonight, it will be posted to YouTube. So they all, I think that the YouTube link was sent out. It's posted to my YouTube channel, which I can just post. I know that. Oh, yeah, there's links to it on Twen, but I don't know if there's links to it for every single one, Andrea. But if you see like one of the links, it's all the same link. If you go there, it's my channel, which just has these videos on it, and that's it, obviously. But Luciana, I can see if I can email it to you because I think I have your email address. So I will do that. It just takes me a day to do it because it takes forever to process the video. And I don't know if am I having class on Super Bowl night? Oh, I don't want to. Let me look. Let me see. It's also my best, whatever. How do you get access to bar essays? You got to contact Professor Matsumoto or Professor Israel or Professor Berger for that, Adam, to get bar essays. All right, everybody, have a good evening, and yeah, I'll see ya. Ta-ta for now, Andrea. All right, I'll see you guys all later. Bye.